so the next case is Medina County Job and Family Services versus Dennis. Both sides will have 15 minutes to present their arguments, and the appellant may reserve up to 5. Thank you. Just let me know if you want to reserve some time.
Thank you, Your Honor. I'd like to reserve 2 minutes.
That's fine. Thank you.
May it please the court, I'm Derek Check on behalf of the appellant, Mario Dennis. We're here this morning on an appeal from a juvenile dependency adjudication. And I want to focus the court on really 2 points of law that I think are the most germane and really what decides this case. And they both come from the Ohio Supreme Court. First point that we look at is that you must show an actual adverse impact on a child to have dependency under 2151.04c. The Supreme Court has been clear, it said that a long time ago. Point number 2 is that when a child is receiving adequate care by his parents, that child is not dependent. Again, the Ohio Supreme Court has said that. That is the framework in which we take a look at complaints under Section C. The facts in this case are pretty simple.
Let me ask you before you go any further. What actually was in the complaint?
The complaint had, I believe, counts for abuse, neglect, and dependency. Neglect, I believe, was voluntarily dismissed. Abuse, the trial court dismissed, and dependency was found under C. So in this particular case, the Medina County Drug Task Force raided the parents' home. They had an apartment there in Medina. At the time they did the raid, one of the detectives, Mary Gross, came along for the raid. Her job was essentially to deal with the children, keep an eye on them. And I think that is another point that the court needs to focus on. And what is not in the record, which is very important, is there was no Juvenile Rule 6 executed that day when the warrant was executed. And I'm going to say that again just for emphasis. There was no Juvenile Rule 6 executed when the warrant was served and executed. And that's important because they could have Juvenile Rule 6 these children immediately and taken them into custody if they found that there was such a hazard. But the police and the Drug Task Force didn't do that. They allowed the parents, the mother particularly, to contact relatives and find placement for her 3 kids. And she contacted the paternal grandmother of Tahia, who is the child in this case, and that's Patricia Dennis, and made a placement there. The issue comes in after that, where Medina County Job and Family Services wasn't able to get in contact with Patricia Dennis, and therefore they filed this case and they asked for removal of the child from her home. The police had no issue with Patricia taking the child. And so that is the point the court needs to focus on. And the court's going to hear, yes, both these parents were arrested, and they were arrested, and both of them were still sitting in the jail at the time of the adjudication. That's not disputed. However, those facts and their convictions or what came out of those criminal cases are not in the record. In fact, the warrant itself is not in the record that was served to execute on the parents' home for the Drug Task Force. We don't know why they came there. We don't know what they were looking for. We don't know what they recovered out of that home because none of that's in the record. All we know is the police came in, there were 9 people in this home, or 9 children I should say, some adults, they arrested a bunch of people, the kids all went to placements, and that's all we know.
Well, we also know that from the testimony of employees of Children's Services that attempts were made to contact grandmother at a time that was designated and that she did not appear at the home. They waited for maybe 30 minutes or so. And I'm not sure exactly what the testimony was, but they described her demeanor as being uncooperative once they finally were able to reach her.
They did. There was testimony in the record that there was an appointment, I believe it was either 4 or 4:30, to meet with the grandmother at her home. She wasn't there. I believe the testimony was they waited a half hour. They then went to the home of the father of one of the other children, met with him, came back. It was about 7:30 or so. They met with the grandmother at that point. They saw the home. But in between, they had decided that they were going to remove those children.
Well, they said in between, as I read the briefs, that they had made several phone calls to the grandmother and she did not respond. So during that time, they didn't know where TV was.
That's correct. However, I think what the court has to focus on is The issue is not, did she cooperate and was she available the moment in time of when they tried to get in touch with her. And the reasoning is because Medina Drug Task Force allowed mother to make that placement. They did not intervene, they didn't Rule 6 these kids, and so there was no questioning at that point. I mean, Mary Gross had seen the grandmother, she appeared and took to Haya, and she didn't have an issue with her. Now, she didn't do a thorough investigation, but again, her job was not to do a thorough investigation. She saw that this person was there, appeared suitable, she took the child. The issue then becomes, was the grandmother somehow unsuitable? And you have to take the time to do the investigation, and I think that's the problem with this case, is they jumped the gun and then just said, we're removing the kids and this is dependency.
We'll talk a little bit about what we're going to find in the record about what happened once they did meet with the grandmother at the home, because I got the impression that they felt that their investigation was thwarted in some respect by the grandmother's not being cooperative.
I think what they found, I think what the record showed is Ms. Kohler testified that she had seen the front room of grandmother's home and there was nothing wrong with that. They didn't apparently do any further investigation and look around the house or check it out or whatever. When they returned, the police actually came with them. So at that point, they were already determined and had decided they were going to Rule 6 the kids at that point. So grandmother's, I guess, cooperation or lack thereof made no difference at that point in time because it was already sort of a fait accompli at that point. I think the record would show that she was uncooperative in the sense that she didn't respond, number one, to their 4:30 appointment or 4 o'clock, that she didn't return their calls when they were trying to reach her. But again, that does not equate to dependency.
Well, is there anything in the record to indicate that she obstructed their ability to view the rest of the house?
No, I don't think that there's anything in the record that indicates that. I think that at that point they weren't looking to do the rest of the house. They were looking to take these kids out of there and place them in foster care. So the issue is simply not grandmother's conduct. And I think that, a lot in the record and a lot of the trial was focused on what did grandmother do, what did she not do. That's not the issue. The issue is, were these children receiving proper care at the time Medina County Drug Task Force entered that home? And the answer is yes. The record sustains that. Mary Gross's testimony shows that these kids looked like they were bathed. They looked like they were feeding. She didn't see concerns of abuse or neglect. Children were receiving proper care. So the Ohio Supreme Court is the case law we have to follow, and that law is clear. If these children are receiving proper care, they are not dependent, period. The burden is on Medina County Job and Family Services to show an actual adverse impact.
So the testimony in the record that speaks to the chaotic situation, the number of unrelated males in the home, and crying children. At the time that the search warrant was executed, does that fulfill the obligation of the agency?
And yes, and the answer to your question is no, it does not. That is in Medina County's brief, and the answer is no. I mean, obviously, if you have a whole bunch of adult males and a bunch of children, some that are very young, and the police enter a home and they execute a search warrant, and they're coming in full gear, it's going to be chaotic. That's understood. I think to look at it a different way or analogize to a different situation, chaos can arise from any situation. You can have a car accident, and that's going to be chaotic, and that's going to be traumatic. But that does not mean there's an adverse element in the environment of the children.
But the drug force comes in, and there's drugs in the premises. Is that correct?
No, the record I don't believe indicates that there was any drugs recovered there. And that's the problem, is the record doesn't say what they found, what they were looking for. So we're left with a void. And again, we have to focus on, the key thing here is there an adverse element in the environment of the children that will cause them to grow up abnormally? That's the dependency inquiry under C, and we don't see that in the record. Now, could this case have been different if different testimony came in? Yeah, probably could. But that testimony is not there, and we have to work with what we have.
So for example, had the officer who executed the warrant been called, rather than the one who was called to see about the children, we might be having a different discussion.
I think we might be. For example, if the officer came in and testified and said, I found 5 pounds of heroin, this might be a very different case. If he testified he found whatever there, cocaine, marijuana, it could be a very different case. But he didn't testify, and that's the problem. It's not that perhaps Medina County could not improve their case, it's just that the record doesn't sustain the finding. And so that's what we have to look at. We have to look at, was an actual adverse element in the children's, or the child's life in this case, shown, and it was not. And so the Ohio Supreme Court has said that child is not dependent. So the law is very clear, and I just ask that the court keep that in mind, and keep in mind that there was no juvenile Rule 6 executed at the time the drug task force went into this home. I think that's where the court needs to retain its focus.
And you're actually down to 4 minutes.
Okay, thank you, Your Honor. And if there are no further questions, I reserve the balance of my time.
That's fine, thank you.
Good morning, Your Honors. Excuse me. May it please the Court, my name is Jennifer Moore, and I represent Medina County Job and Family Services. I think Mr. Check brings up a couple of points that the agency didn't focus on when it did the adjudication. When the agency was looking for the dependency was based on the fact that parents were arrested and incarcerated. The agency was not called until the day after the arrest and after Medina County Drug Task Force and Medina City Police Department placed the children with Patricia Dennis. The problem with that is, although mother made a plan for the children, no one was able to ascertain whether or not that was an appropriate plan. And I think the case law is clear, especially in Ray LW, which I cited in my brief, was that the plan that a parent makes has to be an appropriate plan. There were 3 children. The agency handled this case with all 3 children in mind, not wanting to split up sibling sets. Although we are only here for TD, at the time of the agency's filing, she was 6 months old, which means she had no ability to self-protect, she had no ability to meet any of her own basic needs, and the agency needed to ascertain the safety of paternal grandmother when the agency became involved the following day.
What do we know in the record that the agency did in order to do that?
The agency, I believe Ms. Kohler testified that the agency attempted to contact grandmother throughout the day, ultimately did make this appointment for, I believe it was 4 o'clock in the afternoon, and then to try to ascertain, because of the concern with whether or not grandmother could get the children enrolled in services, the agency did file at 3:20 on May 15th. We did file a complaint, figuring then if the children were safe and it was an appropriate setting, the agency could then dismiss the complaint. The concerns then arose when grandmother missed the appointment and the agency could no longer ascertain the safety of those children.
So, just to be clear, the agency filed the complaint at 3:20. That's the time of the afternoon.
Correct.
With the knowledge that there was an appointment with grandmother at 4 or 4:30, one of those.
I believe that the appointment was set simultaneously with the filing of it was right around at the same time.
Okay.
Well, how would you know at that point in the final complaint?
The concern was that Miss Dennis is only the grandmother to TD, and like I said, we had 2 other children that she had no blood lineage to.
But TD is the only child who's a part of this appeal.
Correct, but like I said, our thought process, I mean, we don't plan, when we do our case planning and our services, we don't plan on separating them out for appellate purposes. We work as a family unit, and it was a sibling set of 3. The concern that we had was the trouble we had getting a hold of the family earlier in the morning.
So what were your allegations in your complaint?
The allegations were that the children, we did file, as Mr. Check said, we did file the abuse and neglect dependency. The allegation was that there was a raid in the home, that the scene was chaotic, that parents were subsequently arrested and were currently incarcerated, and that the children were placed with one child's family member, and that family member had no paperwork in order to seek medical or schooling should the children need either of those things, is what the complaint was.
So it's just on the basis that there wasn't the proper paperwork for sufficient care?
And we also weren't sure what type of environment that the child was in at that point, because we had not been able to ascertain that.
Which gets them into their prospective dependency argument.
I think at the time we filed that may have been true, but then after we were able to complete our investigation, which is why we went forward the following day with shelter care. The original case was on an ex parte basis, and then we supplemented that testimony the following day at the actual shelter care hearing.
So by that time, had you been able, when I say you, I mean the agency, have been able to review the residence of the grandmother to determine if she was appropriate?
As Ms. Kohler testified, at that point when the agency went out, we were only able to view the living room. Ms. Dennis, as Ms. Kohler testified, was, I don't want to use the word hostile, and I don't recall the word that she actually used, but she was defensive, did not seem to want to work with the agency at that point. And the agency had concerns then because we weren't able to view everything, we weren't able to see what type of supplies she had for the child. And like I said, this was a 6-month-old baby, so she would need formula, she would need diapers, she would need a crib, which she did not actually have at that point, if I recall from what she had told the worker. And I don't honestly remember if that is in the record. But she, so we were not able to fully ascertain whether or not this person could provide adequate care.
So it's a little fuzzy as to whether or not the agency said, for example, this child was released to you by the mother. We're here to look at your home to determine whether or not this is an appropriate placement. Do we have your permission to look around?
And that was the original intent of the 4 o'clock appointment.
Yeah, I understand that. What I'm saying is, what is in the record other than, well, she just wasn't, she was defensive? I mean, what are we going to find as to whether or not the agency even said, may we look around to determine whether this is an appropriate placement, or whether, as your opposing attorney said, they'd already decided, we're going to remove the child?
I recall Ms. Kohler's testimony vaguely as in she did go into the residence, they tried talking with her about the concerns, the fact that Ms. Dennis had missed the appointment, and I think things just kind of decompensated from there. And I believe that that's what Ms. Kohler's testimony was, is because of some of the defensiveness and the possible hostility, that's what the record will say, is that the agency didn't feel it was a safe situation and at that point removed the children.
So there's an answer to the question, that there's really nothing in the record that indicates what exactly was said.
I don't believe that it was verbatim testimony about the conversation between Ms. Kohler and Ms. O'Connell, the other worker, and Ms. Dennis.
If I may, Ms. Dennis took all 3 children, but this is the only child that is her biological grandchild?
Correct. Although there was concern at the agency earlier in the day that she did not have all 3 children. When we presented to the house at, I believe it was probably about 6 o'clock at that point, she did have all 3 children with her. We had received conflicting information beforehand during what we tried to investigate during the day.
Just out of curiosity, were the other children that were attempted to be placed with their family, paternal families? Paternal families?
Mother had not noted any family from her side. The middle child has no paternity established, and father of the oldest child has a lengthy criminal history. And that was actually part of the complaint on that child. So the agency did not feel comfortable leaving that child with his father. So the agency would argue that it was not able to ascertain whether or not TD was receiving the adequate parental care, or the adequate care, as noted, because the agency was not able to make that full investigation due to the time constraints and the issues that happened with the grandmother missing the appointment. With regard to a juvenile Rule 6 not being issued, Detective Gross testified that she did not check out Ms. Dennis. Her testimony was that she ran no background check. She allowed mother to call the relative and gave the children to the relative just based on physical appearance. So there was no way for them to they did not determine the safetiness of the placement, which is another reason the agency had concerns with regards to whether or not it was a safe placement. They would argue that dependency was warranted under 2151.04c. We would argue that the case law on this shows that if we do relate back, although the agency's position is that it's from the time that parents were arrested, and we filed the complaint after parents were arrested and incarcerated, and whether or not TD was receiving adequate parental care under the plan that mom did not voluntarily make, but had to make because of her arrest. We would argue that if we do go back, as Mr. Check stated, that there was a chaotic situation, and that chaotic situation can negatively impact a child, which is one of the factors in looking at a dependent child. There were police in the home. There were a number of men in the home, and Detective Gross testified to the chaotic scene. She testified to the children crying. She testified to the officers in the home. So if we relate back to that, that was a negative impact on the children. That was an environmental element that was adverse to the normal development of a child.
Well, an argument could be made that the chaotic situation was brought about by the execution of the search warrant. We don't know what the situation was like before the officers arrived, correct?
Correct.
And particularly where we don't have the search warrant in the record, nor do we have any testimony from the investigating officers as to what gave rise to probable cause.
And I think that's where why the trial court did not find an adjudication of abuse. I think that's why he dismissed that.
But even as to dependency, the same question remains.
Well, I think that the dependency, and like I said, the agency's position is that when we filed the day after, parents were arrested, parents were incarcerated, parents could not provide adequate care to TD. The agency was not able to ascertain whether or not the plan that mother made involuntarily was enough to provide that adequate care to TD. So TD, who is 6 months old and can't do anything for herself, doesn't have a proper custodian or someone that can provide food, clothing, diapers, shelter, a sleeping arrangement. That child is a dependent child because she has no one to meet her basic needs. And that was what the agency was not able to ascertain at the time that it had filed its complaint. So we would ask that the court uphold if there are no other questions.
Thank you.
We would ask that the court uphold the trial court's decision. Thank you, Your Honors.
Thank you.
Your Honors, I think in rebuttal to a couple points, first of all, life is chaotic. If you raise children, there's going to be some events that happen in your life that are going to cause a whole lot of chaos. It doesn't make them dependent children. Number two, mother's plan was voluntary. If it was involuntary, it would have been a juvenile Rule 6. The police gave her the choice, find some providers for these children, your 3 children, in this particular one that we're focused on today. She did that. Those plans are not voluntary. They may not have been her desire at that moment because most people don't want to be placed in cuffs and taken to the jail, but she made the plan.
That's a very interesting observation, that it was voluntary because the police gave her the space to do that. But I'm not sure that we can say that just because they weren't Rule 6, that the placement was voluntary, where there was apparently arrest warrant for both parents.
Well, I don't know that the record even supports that. I think, first of all, my client was not present in the home when the warrant was executed. He was arrested later at a different day, different time. Mother was taken, I believe, that day. But the problem is that we don't know a lot of things because the record is void on those subjects. But again, involuntary connotes something that you don't have the ability to do this. For example, you were hurt in a car accident and there's a deceased father, therefore the child is dependent perhaps. Or that something else is going on in the environment. You know, you've had a drug overdose, therefore you couldn't make a plan. This mother made a plan. She was totally capable of doing that. The police allowed her to do that. In fact, they even sent a detective specifically to keep an eye on the kids to make sure that they were all provided for. And they allowed mother to do that. If they didn't like the situation, they would have immediately taken those kids out of there, put them under Rule 6, and moved them and called the agency. That didn't happen. And I think that's another point the court should keep in mind as it looks at this. The prospective dependency argument, I think I've argued that before this court several times. I would just note for the court, the Ohio Supreme Court has expressed a lot of skepticism about prospective dependency. We're under Section C, not D. Under Section C, you have to have an actual adverse impact. So I'd ask the court to reverse the judgment of the trial court. Thank you.
Thank you, thank you. The court will take the matter under advisement. That microphone is already working.
Yeah. Can we see about turning down the volume of the microphone so we don't have so much feedback? Please.
I didn't know. Anyway, so we'll take the matter under advisement, and we'll issue a written opinion that will be sent to both sides, and we also release on our website. So thank you so much.
Thank you very much.